Hi, and welcome to Topic 10, Lecture 1. And in this lecture, we are going to be taking a look at the right to privacy as it applies to abortion rights. As usual, I'm going to do two lectures for this topic, but I thought I'd give you the overview of both the lectures at once so that you have an idea of how these lectures are connected. Both of the lectures are going to deal with the abortion rights issue. But I will create course commentary and also expect you to do the reading on the other right to privacy cases, which move beyond the abortion and contraceptive issues, in particular, the right to sexual privacy and the right to die. But what are we going to be taking a look at in these two lectures? Well, the first lecture is going to be dedicated to Roe v. Wade, okay? That's what the first lecture is going to look at, okay? And so we're going to look at abortion laws prior to Roe. We're going to look at the facts of Roe, and then we'll go through the reasoning in Roe. It's an important case and deserves basically its own lecture. In the next lecture, lecture 2, we're going to take a look at what happened after Roe v. Wade and sort of where we are today as it relates to the jurisprudence on the right to privacy as it applies to abortion. And so we'll look at the aftermath of Roe. There was a big backlash to the decision in Roe. Prior to Roe, it really wasn't a political issue. It wasn't a salient issue like it is today. But following Roe, there was a pretty big backlash to it, and there was a lot of polarization that took place. And so we're going to look at some of the legal responses to Roe that were exercised at states, so states' attempts to limit the decision of Roe, and then also look at cases that came to the Supreme Court in an attempt to overturn Roe. And then we'll spend most of our time in the next lecture taking a look at Planned Parenthood of Southern Pennsylvania v. Casey. And then we'll finish off our conversations looking at abortion and the Roberts Court, so sort of where we are today. So really the two big cases, for abortion rights are Roe and Casey, okay? There are other cases that your textbook talks about, but those are the two sort of most important cases that you need to understand, and I really expect that you will read the full decisions and dissents for both of those cases. So last week we spent time learning about the establishment of the right to privacy by the Supreme Court. And so you read about the Griswold v. Connecticut case, and we know that the court had established a right to privacy in Griswold, that they deemed it a fundamental right, and because it was a fundamental right, that when evaluating regulations on the right to privacy, the strict scrutiny should be used, okay? And so that's why Griswold is such an important case. The major question coming out of Griswold was what's covered by the right to privacy, okay? So the right to privacy in Griswold dealt with the use of contraceptives. The question is, okay, well, what else does the right to privacy apply to? And the big question is, does it cover the right to abortion? And so you have a right to privacy when it comes to contraceptive use. Do you have the right to privacy to terminate a pregnancy? And many people were really eager. This is for the court to take up this issue because, this was the late 60s, early 70s. Roe was heard in the early 70s. This is a time period where there is a lot of social movements, in particular, the women's rights movement. And one of the big issues with women's rights movement is the issue of having that if you really want to have equality in terms of education and equality in employment, you have to have control over your reproductive freedoms. And that's not just using contraceptives, but that's using being able to have an abortion as well. And so people, in particular, those who wanted the abortion to be considered a fundamental liberty that is included under the right to privacy, they're really eager for the court to take up the question about whether or not the right to privacy applies to abortion. And the court answers the question in the landmark case, Roe v. Wade. So let's take a look at that. So before we get into the facts of the case, I want to look at some of the background information that they provide in your textbook. And there are some things that I want you to keep in mind. So one of the things I want you to keep in mind, and I sort of referenced this in the last slide, is that attitudes towards abortion in the 1960s and 70s is really different than attitudes towards abortion today. for a long period of time in U.S. history, really up until the end of the 19th century, abortion was sort of seen as like the private realm of women. It was, sort of like men were in the public realm, women were in the private realm, and issues about contraceptives, childbirth, pregnancy, those were all sort of like kind of sequestered in the private realm of women. And so there, really wasn't a lot of legal regulations on abortions, contraceptives, and those sorts of things until the end of the 19th century. And so even after as we move into the 20th century, it just doesn't have the same sort of political salience as it did, back in it doesn't have the same sort of political saliency as it does today. In fact, until the 1980s, within political parties, the Democrats, after Roe v. Wade, the Democratic Party supported the decision in Roe, and the Republican Party supported the decision in Roe, right? So there were pro-choice Republicans, pro-choice Democrats. It just didn't have the dividing sort of aspect as it does today. Today, it's a very, very divisive and polarizing issue. But not in the past. And I want you to keep that in mind, because as Roe comes to the court, it's not quite as divisive, right? I mean, feminists want the court to take this question up and answer the question about whether the right to privacy extends to the right to abortion. But there aren't these battle lines drawn between the pro-life and the pro-choice movement. That comes after Roe. Now, in the 1960s, most states have laws allowing abortion, okay? But they're pretty draconian laws. They're very, very limited. That most states allow abortions, but most of the states only allow abortion in the case of life or death, right? Only in the case of that, if the mother brings this fetus to term, the mother will die, okay? And that's the only time you can get an abortion, if the life of the mother is being threatened. In the 1960s, we see that states begin to liberalize their laws. And so it doesn't matter whether you have a constitutional right to an abortion, right? Well, it matters. I mean, let me rephrase that. It does matter, right? That because if you say it's a fundamental liberty, then states cannot criminalize abortion, right? But even if it's not a fundamental liberty, right, states can still have very liberal abortion laws, right? There's nothing prohibiting states from doing that. There's also nothing prohibiting states from criminalizing abortion laws if it's not viewed as a fundamental right. So in the 1960s, we actually see in states that growing liberalization of laws, allowing abortions for other reasons than just to save the life of the mother. And there's a rise because it's the 1960s. We have the rise of the women's rights movement. And so that you have women's rights groups flooding the court with lawsuits because they want the court to decide whether or not the right to privacy extends to abortion. And the Supreme Court agrees, as you'll read in your textbook, to hear two cases. One is Roe v. Wade, the landmark case, and the other is Doe v. Bolton. These cases are different in that Roe v. Wade deals with a Texas law that's very restrictive. It says you can only get an abortion if the life of the mother is in jeopardy. Doe is based on Georgia law that allows abortions for other reasons as well. Incest, fetal abnormality, and those sorts of things. And so the court was sort of, hearing two cases, one case that had a very restrictive law and the other case that had less restrictive laws in Georgia. But we're going to focus on the Roe v. Wade case. So this is just the graph from your textbook that shows the different levels of abortion laws that are in place prior to Roe. The states are in white, and you see Wisconsin is in white, and so is Texas is in white as well. Those are the states that allow abortion only if the life of the mother is in jeopardy. Okay, so very restrictive abortion laws, and that's kind of abortion law that comes to the court in Roe v. Wade. The light blue or gray, whatever color that is, states, and you see Georgia right there because the Doe case deals with Georgia law. Those are the states that say you can have an abortion if the life of the mother is in jeopardy, but also for other reasons as well, but still pretty restrictive reasons, such as that you can have an abortion due to if the pregnancy is a result of rape or incest or fetal abnormality, etc. So specific circumstances. And the dark blue states, you've got Alaska, Washington, New York, as well, the state of New York. Those are basically abortion on demand states, right? So they had very liberal laws. And women could go from state to state. Like if you lived in a white state and you wanted to get an abortion, if you had the means, you could go to one of the other states to get an abortion. But that just kind of gives you an overview of the laws that were in place prior to Roe. So sort of the impact that Roe has on basically, criminalizing the kinds of law, or finding unconstitutional the kinds of laws that criminalized abortion unless it was to save the life of a woman. Another slide I want us to look at before we talk about Roe is looking at public opinion over time. And this is a cool graph because it really shows the trend in public opinion since right after Roe in 1975 to, today or ish, 2017. And it breaks down the public opinion. This is based on Gallup polling. It breaks down the public opinion on abortion according to three sort of different attitudes. So the first attitude is legal under any circumstances. And so that would be here represented by the dark line. And so up here, you can sort of see that this is if somebody says that abortion should be legal under certain circumstances, okay? And so maybe saying not abortion on demand, but maybe because of the health or the mental well-being of the mother, maybe economic circumstances, fetal abnormality, that you would say, yes, you support abortion under certain circumstances. The other is the dotted, legal under any circumstances. And so that's this line here. And that's basically saying that a woman should be able to get an abortion on demand during any time of their pregnancy, right? This line up here might be that you think that people could only get an abortion in the first trimester, pre-viability. But here it'd be like, a woman can get a doctor or can get an abortion as a private decision between her and her doctor. It shouldn't be any limits on that. And then the gray line here, illegal in all circumstances, is basically saying that all kinds of abortions, whether it's rape or even if the life of the mother is in jeopardy or incest, that all abortion should be illegal in all circumstances, okay? So, I want you to sort of take a look at that, at the graph and ask yourself sort of like, what are some themes that you see or what are some trends in public opinion on abortion? And if we were in class, I'd be calling on you. I'd say, hey, James. I'd say, Brandon. I'd say, Jarita, Greedy, what's your, take on this, right? But we're not in class together. And so one of the trends that you sort of see here is that there's a lot of stability in opinions regarding abortion. So like when you look at abortion being legal under certain circumstances, in the 1970s, it was about 54, a little bit more than half of Americans who were polled say that. Today, 50%, right? There hasn't been a lot of fluctuation, maybe gone up a little bit in the late 1990s, down a little bit in the 1993, but a lot of stability. You really sort of see that for the most part in terms of illegal in all circumstances. Boy, that's been a pretty stable number from 20 to 18, right? So it's like people's viewpoints on that really don't change. And we see a little bit of fluctuation in 1993 under legal under any circumstances. But again, 29 here, 22 there. So maybe a little bit of an increase there, but relatively stable. And so I want you to ask yourself, like, why are those opinions pretty stable? If you look at public opinion on something like same-sex marriage, that opinion has changed drastically, right? So like if you look at public opinion on same-sex marriage and whether you support same-sex marriage, even 20 years ago or 15 years ago, that there was strong opposition to same-sex marriage. Today, there's a lot less opposition to same-sex marriage. It's really changed. But in abortion, it's been pretty stable. Maybe think about what are some of the factors that contribute to that. I think when it comes to having an opinion that abortion should be illegal in all circumstances, that's probably a reflection of a person's religious beliefs, right? And that those religious beliefs have been stable over time, and like, particularly evangelical Christians and Catholics too. Basically that approach, those theological doctrines haven't changed, and they haven't changed in a lot of the adherence to those doctrines either. So just something to keep in mind. The final thing I'll say is there's not a gap when it comes to public opinion. You would think that women would be more likely to be pro-choice, sort of saying that abortion should be legal in either all circumstances or legal in some or most certain circumstances. That's not the case. That there's not a so-called gender gap when it comes to abortion rights. And so that's kind of interesting to keep in mind. You can take my Sex, Power, and Public Policy class in the fall if you're around, because we go into that in a lot more detail in that class. Okay, so finally on to looking at the facts of the case of Roe v. Wade. The facts of the case in Roe v. Wade are pretty straightforward. That an individual, her name was Norma McCorvey, but she, because of privacy reasons, went by a pseudonym, Jane Roe. That she wanted to get an abortion in the state of Texas. The state of Texas, as we saw in the previous slide, had a very strict abortion law on the books. Basically said that you could only get an abortion if the life of the mother was in jeopardy, and that was not the case for Norma McCorvey, Jane Roe. And so with the help of lawyers who were eager to find out whether or not the right to privacy extends to abortion, that this case worked its way through the court system and was finally granted a writ of certiorari by the Supreme Court. And so, the facts of the case, just on its surface, are very straightforward. The question is the Texas law, does it violate the woman, or does it violate the constitutional right to privacy? But as you're going to read in your textbook, sort of the backstory of Roe is really pretty interesting. There's a whole box that you can read about Norma McCorvey, a really interesting person. She lived sort of, kind of a sad, she struggled in her life. I guess I'll just put it like that. She was 21 when she sought out her abortion in Texas in 1970. She already had 2 other children, and so she was pregnant with her third. She lied about how she got pregnant. Maybe she thought that the doctor that if she lied and said that she got pregnant as a result of rape, that maybe he'd take mercy and perform an abortion on her. That was not the case. There was no exception for rape pregnancies in Texas law. Turns out later on that she said she just lied about that she did not get pregnant via a rape, but she said that because she, was ashamed of her actions at the time. She never got an abortion because by the time the court case worked its way through the court system, she had already delivered the baby and put it up for adoption. And she kind of became, she was just seeking an abortion. She had no idea that she'd become this sort of like cause, a celebrity cause that, that Jane Roe kind of became. You'll read in the textbook that Norma McCorvey, after Roe v. Wade, nobody knew who she was. She stayed out of the spotlight. She was anonymous. She didn't come out as being Roe. But then in the 1980s, she did come out as Roe, and you can see that there in the photograph, that's her with a lawyer, a pro-choice lawyer, somebody who's supportive of abortion rights. And she was pretty active in the abortion rights movement. But then later in life that she switched sides, and she said that, and she joined the pro-life movement. And she was an outspoken opponent against abortion, as you can sort of see from the sign there, post-abortive women say abortion hers. And then there's a final twist to the story that right before she died in 2017. There's an FX documentary about it if you want to watch it. She comes out and said that she felt like she was used by both sides, really the pro-choice movement and the pro-life movement, and that the only reason she came out as pro-life is that they were giving her money in order to show up at rallies, and she needed the money. So kind of an interesting life, a little bit sad. She struggled with poverty and addiction for most of her life, and she ended up dying relatively young in 1969. So let's look at at the age of 69. She died in 2017. Let's go ahead and look at the question before the court. So the question before the court in Roe v. Wade is abortion a fundamental right under the privacy set out in Griswold? In other words, does the Texas law prohibiting abortion is that an unconstitutional law? Now, keep in mind that on the Roe's side, her attorneys were arguing that the Texas law infringes on this fundamental right to privacy, and that decisions that you make about your pregnancy is a private, personal matter. They also said that the statute forbidding all abortions except in the save the life of the mother, that they said that there was no legitimate health concern or real interest in protecting human life that was associated with that law. And Texas, on the other side, basically said that the right to an abortion is not a constitutional right, that privacy is not an absolute right, and that the states can regulate access to abortion. They can even prohibit abortion in order to protect the life of the fetus, and also to achieve the legitimate sort of regulatory powers of states. So the question before the court is abortion a fundamental right under the privacy set out of Griswold, and we know the answer to that question. In a 7-2 decision, Justice Blackmun, they say yes, that abortion is a fundamental right under the right to privacy, and strikes down the Texas law. And Justice Blackmun writes the opinion. Now, make sure that you read in the textbook. We'll go over the reasoning in Roe in one moment, but make sure that you read in the textbook the complicated path of the court's decision making. There was a lot of concern about how the justices, they were trying to get enough votes to, find that the right to privacy applied to abortion. And so they were sort of making sure that there were enough justices in the majority. They wanted to write the opinion in a way to make sure that people could join on to the majority opinion. They were really worried about changes in the court, that they thought they were going to lose 2 justices who were pro-choice, and they were going to be replaced with pro-life justices. So there was all this sort of wrangling that was going on. And also that the Roe was had 2 arguments in front of the court. And so they had one oral argument, and then they decided to do it again later on. So it's a really interesting story. So make sure that you read that, all the wrangling behind the scene with the court. So what is the reasoning of the court in Roe? The first thing that they say is that the court recognizes that there is a right to privacy, and that the right to privacy includes the right to have an abortion. They seat that right to privacy in the due process clause of the 14th Amendment, that says that the states cannot take away the life, liberty, or property of a person without the due process of law. And so they locate this right in the due process clause using the substantive due process doctrine. But they say that the word person in the 14th Amendment does not refer to the unborn child, to the fetus. They're basically saying that you can't take away the right of liberty or life of a person. That's a person who's outside of the womb, not an entity that is yet to be born. So it's saying that basically saying that fetuses do not have these constitutional rights to liberty or life. They deem it a fundamental right, and then they say that if there are going to be regulations on this fundamental right, that those regulations will face strict scrutiny. And so again, it's in line with what was stated in Griswold. However, there's a little bit of a twist. They say that just because it's a fundamental right doesn't mean the right to an abortion is not absolute. No liberties are absolute, but that they say that there are limits on the right to the constitutional right to have an abortion. And so basically what they say that early in your pregnancy, that the rights of the individual are much greater than the rights of the state, because that the fetus is not viable. But as the pregnancy progresses and the fetus gets closer to viability, the interests of the state increase in substantiality, right? In other words, that prior to viability, women have an unrestricted right to an abortion. States can't interfere with this fundamental right. However, after viability, the interests of the state grow, and that those interests of the state become compelling, okay? And because it's a compelling interest, as the pregnancy gets closer to term, as the fetus becomes more and more viable, that basically, even though strict scrutiny is being used, the compelling interest of the state is so strong that the state can regulate later term abortions, and they can also prescribe or prohibit later term abortions as well. So just to reiterate the points that I made on the past slide, that the major takeaways from Roe is that the right to privacy applies to abortion, that the right to privacy is a fundamental right and subject to strict scrutiny, but with this sort of twist in it, that the state's interest in the mother's health and protecting the life of the fetus increases as the pregnancy advances. And so the state's interest early on in the pregnancy are not compelling enough to restrict abortions in the early terms of the pregnancy. But as the pregnancy gets closer to past viability, and as the pregnancy gets closer to like where somebody is actually going to give birth to a child, that the interest of the state becomes quite compelling, and therefore the state can basically prohibit late-term abortions or put really great regulations on later-term abortions because the interests of the state are so strong. And this is articulated in what's known as the trimester framework. So let's take a look at the graph in your textbook that sort of articulates the trimester framework that's developed in Roe. Okay, so let's take a look at the graph in your textbook that articulates the trimester framework. So it's been a while since I had a kid, but as I recall, I think it took about 9 months for that kid to pop out. And so that there are different trimesters within a pregnancy. A trimester just means a period of 3 months, okay? So you have the first trimester, the second trimester, and the third trimester. And as it says here, that prior to the end of the first trimester, so that is prior to viability, from 1 month through the third month, that when it comes to the permissible state regulations on the decision to terminate the pregnancy, in the first trimester, as it says there, there's almost no permissible regulations. That the abortion decision is left to the woman and the medical judgment of their doctor. In the second trimester, from months 4 through 6, that at that point, that there is some permissible state regulation. It says that the state, in promoting its interest of the health of the mother, may, if it chooses, regulate the abortion procedure in ways that are reasonably related to maternal health, but it may not prohibit abortions in the second trimester. Keep in mind, where we're at today with abortion regulations is really different than this, okay? And so here the focus is on maternal health. They're basically saying that the interest of the state is more compelling in the second trimester because as you move on in your pregnancy, terminating a pregnancy can be more dangerous, right? The fetus is bigger. There's the consequences of an abortion that doesn't go right. There could be more bleeding, etc. And so they're basically saying that that's the state interest to make sure that the mother's health is protected in that second trimester, and the state regulations have to be related to maternal health, nothing else. And then in the subsequent to viability from 7 to 9 months, that the interest of the state is very high. And so the state, in promoting its interest in protecting the potential of human life, it could choose to regulate or even prohibit abortion, okay? So as the pregnancy progresses, the interest of the state got stronger to the point of the third trimester, where the interest of the state in preserving the life of the unborn child, of the fetus, are compelling to the point of being able to highly regulate or even prohibit abortions. So the decision in Roe was a 7-2 decision. There weren't a lot of dissenters. And as you'll read in the textbook, that was kind of surprising. They thought there would be more dissenters. But we do have 2 dissenters, Justice Rehnquist and Justice White. Justice Rehnquist actually becomes the Chief Justice of the Supreme Court after Burger. So, this is his early tenure on the court. We're looking at these dissents because while the decision in Roe was 7-2, right now there's probably not any certainty that there is an actual majority support for Roe v. Wade. And we're actually going to take a look at that in our next lecture. And so the concerns of the dissenters are very strong concerns that maybe the majority of the current Supreme Court has when it comes to the constitutional right to an abortion. Rehnquist and White thought the trimester scheme was a joke. They didn't like it. They didn't think it was workable. And in fact, the trimester scheme gets thrown out in Casey. We'll be talking about that in the next lecture. Because the right to privacy was seated in the Due Process Clause of the 14th Amendment, they basically said, look, dudes, we've already thrown out the due process, the substantive due process doctrine. It's already been discredited. Okay, so why are you bringing it back up now? It was discredited in the late 1930s and 40s. So they basically said that the right to an abortion is not a fundamental right. It should be treated the same as an economic right, okay? And therefore, that you don't have to show that the state has a compelling interest to regulate economic rights. You don't need to show that the state has a compelling interest to regulate the rights of an abortion. So from their perspective, when evaluating abortion laws, you just need to use the rational basis test. You don't need to use the strict scrutiny test. In other words, regulating abortion is constitutional if the state can demonstrate that the law is related to a legitimate government interest, not a compelling government interest. So, for example, you could easily say that a state has a legitimate interest in preventing immorality and that you don't want people to have sex without the consequence of a pregnancy, because if you can do that, immorality will reign. So they could say it's a legitimate interest of the state to prohibit abortion because the state has a legitimate interest in preventing morality or encouraging moral behavior. Using the rational basis test, that kind of regulation based on that justification would be constitutional, but not using the strict scrutiny test. So those are the concerns of the dissenters. Keep that in mind because these concerns are very present on today's Supreme Court. Okay, that's it for Roe. On the next lecture, we're going to look at the response to Roe. And we're going to look at the rise of the Christian right and the rise of the pro-life movement and the impact that had on politics and also the kinds of cases that came to the Supreme Court. We'll look at the key case from that time period, which is the Casey case, and then we'll take a look at abortion and the Roberts courts. Okay, thanks for paying attention, and I'll talk to you again soon.